All right, Facebook Live. Welcome back to this special episode with Max Gardner III. We apologize for the technical issues. Max was sharing some tremendous information for consumers concerning COVID and your mortgages. Um, just to recap quickly, I'm Brad Bodis. I'm with the Bond and Bodis Law Offices, and we are doing these Facebook Live presentations weekly, every Wednesday at 1 o'clock p.m. Central Standard Time, to provide important information concerning financial issues that you've had and are having with respect to COVID. Max Gardner III, my friend Max, my mentor, is here to tell us more about how COVID is impacting mortgage issues. And Max, I'll let you pick back up where you were and share with our visitors the important things to know concerning their mortgages at this point.
Yeah, well, I'm not sure exactly where we cut off, Brad, but what I was trying to get at is the CARES Act, as far as mortgages are concerned, and what is called a forbearance, which is different than a deferral. A forbearance simply means that we're going to temporarily suspend your payments for a period of time, and at the end of that period of time, you've either got to pay the full amount that's due or work out some kind of modification, and there are very complicated rules that apply to it. The CARES Act applies to federally guaranteed mortgage loans. And that's a very important thing for any consumer to know. They need to know to determine if they've got a federally guaranteed mortgage loan, is their note, not the servicer, not who sends them the bill, but is their mortgage note owned by Fannie Mae or is it owned by Freddie Mac?
Right.
And you can go and do a Fannie Mae or Freddie Mac lookup. Just Google Fannie Mae lookup, Freddie Mac lookup, and they'll tell you if they own your note. That would be a federally guaranteed loan. Ginnie Mae is the other actual federal agency that guarantees mortgage loans. That would be FHA, VA, Rural Housing, or USDA. Most people know if they have a VA loan or an FHA loan. These are the mortgages that are subject to the CARES Act. Now, having said that, every mortgage servicer that does not service a federally guaranteed mortgage loan is also offering these forbearances. Your rights are substantially dependent on whether you've got a federally guaranteed loan or a non-federally guaranteed loan. So the first thing you've got to find out is who owns my note. Fannie, Freddie, FHA, VA, Rural Housing, or USDA. The CARES Act specifically says in the legislation, and President Trump signed it March 27th of this year, that the consumer, the borrower, has complete control over whether or not they want to seek a forbearance. And one problem that we've had, we have two class actions pending against Wells Fargo, one for bankruptcy borrowers, one for non-bankruptcy borrowers who did not ask for or understand that they were getting a forbearance. The CARES Act makes it very clear that the consumer borrower is the one that has the right to ask for a forbearance that is totally in their control. You can ask for up to 180 days. The only thing you have to attest to is that I have been directly or indirectly impacted by COVID-19. You don't have to submit any documentation, no financial statements, no bank accounts, no profit or loss statements, no income or expense statements. You simply make that attestation. I've been impacted one way or the other, directly or indirectly, and I don't know anybody that has not been indirectly impacted by the COVID-19.
Sure.
So the decision you have to make is, I want to get a 90-day forbearance under a federally guaranteed loan or 180. You have the absolute right, if you want to get a 90-day or a 30-day or 120-day, you have the right to absolutely say what you want, and for a federally guaranteed loan, they have to give you that. Now, what we are seeing is that even on federally guaranteed loans, a lot of the servicers, the entity that collects your payments and that you deal with, they're offering 90-day forbearances. They're saying you can get a 90-day. I don't know where they came up with that number, but the control is with the borrower. At the end of 180 days on a federally guaranteed loan, if you still think that you're not able to make the payments, then you can extend that for another 180 days. So you can get up to 360 days of forbearance. The problem is twofold with this program. Number one is under Section 4021 of the CARES Act, it says that the mortgage servicer, the party that collects your loan, if you're in a forbearance program, cannot report anything negative on your credit report. And in some sense, that's true. It would not impact your FICO score. But there is a forbearance code in the reporting system to Equifax, Experian, and TransUnion that the servicers do enter. And if you have a forbearance code on your credit report, you're going to have trouble getting credit. It's just that simple.
Right. Now,
that is not something that I think is very transparent in this. I think it's something consumers do not know. Also, they do not report that you missed a payment, but they don't report you have made a payment. So if you've got a 90-day forbearance, say for April, May, and June of this year, your credit report is going to show no payments coming in one way or the other for those 3 months. And that's going to create a problem if you want to try to refinance your mortgage. A lot of the consumers that are not in bankruptcy that we've identified in our class action found out they were in forbearance when they tried to go buy a new car or refinance their mortgage to take advantage of historically low prime rates for people with good credit. The thing that I've tried to do for my clients is I want to know on the front end, we have a lot of clients who need forbearance. I try to see if we can work out what are we going to do at the end of the forbearance? What is the deal? Now, with a federally guaranteed mortgage loan, if you were no more than 30 days in default as of March 1 of this year, you can automatically get a forbearance on a federally guaranteed loan. And that means the 6 payments, the 3 payments, the 12 payments that you had in forbearance are automatically put at the end of your loan as a non-interest bearing balloon payment. And the servicers cannot charge any fees, expenses, late charges, property inspection fees, broker price opinion fees, or any other fees for your doing that. That is for a federally guaranteed loan. And if you were current or no more than 30 days behind as of March 1 of this year. If you weren't current as of March 1, or you're more than 30 days behind as of March 1, then you do not get the automatic deferral. And there's a difference between forbearance and deferral. Then you're talking about some type of program, a mod program that may be offered by Fannie or Freddie, FHA, VA, or rural housing. So you're not in the automatic forbearance. Like in an FHA loan, if you're 30 days behind as of March 1, then you don't get that automatic deferral, but you may get an FHA mod that involves what's called a partial claim. Very complex, very complicated modification in my mind. On Fannie, you may get a Fannie Flex mod, but these are not automatic programs, and I think people need to understand that. The problem we have seen is if you go on your servicer's website, they may have a button that says information about forbearance or information about the CARES Act. And it appears to be just that, an informational button that you click on to, and it's going to tell you what your rights are. And what we have seen is many servicers are automatically putting a consumer into forbearance if they just click on that button, thinking they're getting information. So, I would be very careful going to your servicer's website if you don't want a forbearance. If you want to find out a forbearance, there's publications that Fannie and Freddie have put out. You can Google them and find them on the internet and find out all you need to know about a forbearance before you go on a website, because what we're seeing, if people click on the information site, the automated intelligence will automatically think they want a forbearance and put them in it. And I'm not saying forbearance is not a good thing. It may be a great thing for a lot of people, but if you don't want it, if you don't want to have your credit creating a problem for you with new credit, then be very careful about navigating a servicer's website.
Wow. So somebody may have no interest in a forbearance or are fine making their payments, doing just great, but they happen to click a link and all of a sudden their credit report's impacted and they had no idea.
Well, all of a sudden you're in a forbearance. If you click on a link on a certain servicer's website, the servicer automatically puts you in a forbearance, even though you may be making the payments each month. They may be, you're making them by check, you're making them by credit card, you're making them by debit card, making them by, a bank check by phone card, or check by phone transaction. And you don't even know you're in forbearance. It's going to be automatically reported on your credit report, the forbearance FB code. And then when you go to get new credit or get a new loan, buy a new car, try to get a refinance, you're not in bankruptcy now, because if you're in bankruptcy and you want new credit, you have to get court approval for it. We're talking about a non-bankruptcy consumer borrower. The way most people have found out about it that we're aware of is when they went to refi their current mortgage, not a cash out, but a refi for a lower interest rate, or they went to get new credit, maybe to buy a new washer and dryer on a retail installment contract, or maybe to buy a new car. And all of a sudden, oops, we got a problem. We see you're in forbearance, and we don't see you made the last 3 monthly mortgage payments because they're not showing up on your credit report. It doesn't impact your FICO score. That part of the CARES Act is true, but it does impact your ability to get new credit, because forbearance is going to be a problem. For example, most originators of refinance mortgage loans, if you've been in a forbearance, are going to want to see 6 payments that are timely made at the end of the forbearance period before they even consider you for a refi. So these are certain issues that need to be considered. The other problem we've seen, of course, the CARES Act, in addition to the forbearance program, amended Chapter 13 of the Bankruptcy Code to allow a debtor to modify a Chapter 13 plan to extend the term from 5 years to 7 years. And the thinking behind that was that would be a way, if you got into a forbearance program, that you could cure the number of mortgage payments that were subject to forbearance. The problem with that is, if your Chapter 13 plan was not confirmed before March 26th of this year, maybe it was confirmed April 1, then you're not subject to the 2-year extension under Chapter 13 from 5 years to 7 years. And you cannot file a Chapter 13 case today and get an 84-month plan. A lot of people have read, Chapter 13 is 84 months now. You can do an 84-month plan. They come in and they think, well, I want the 84-month plan. But if you hadn't filed a Chapter 13 and your plan was not confirmed before March 26th of this year, you're not subject to modify that plan to get an 84-month term. And that sunsets March 26th of next year.
Max, I want to just pause for a second here. We sometimes get carried away and start using legal terms that some of our viewers may not understand here. But Chapter 13, folks, is, as we've addressed in some of our earlier Facebook Live events, is a special type of bankruptcy where you can restructure your debt, similar to a corporation, reorganizing and restructuring their debt with the Chapter 11. Chapter 13 is a way for consumers to not liquidate or file a straight bankruptcy, but to file a plan, and in this instance, to catch up mortgage payments that may have been missed over a longer period of time. Some changes have been made to Chapter 13 with the legislation, but as Max just pointed out, many Chapter 13 clients may be prevented from taking advantage of those changes. Just to take a short break here, I'm Brad Bodis with the Bond & Bodis Law Offices. We help people with financial problems throughout Alabama, Mississippi, and in the Knoxville area in Tennessee. During COVID, we are offering absolutely free initial consultations, and we're doing them from the comfort of your own home or office. We'll do them by video or phone or however you feel comfortable and safe. Be proactive. Reach out. As Max has discussed here, there are a lot of important and complicated issues affecting your finances, so don't just sit back. Reach out for help. My guest on today's Facebook Live episode is my friend and mentor to many consumer bankruptcy attorneys, Max Gardner III, out of Shelby, North Carolina. Max is not only a tremendous attorney, he's a tremendous teacher and individual, grandson of Governor Max Gardner of North Carolina, and just a fascinating man. And I want to just put in a plug here. If you'd like to learn more about Max did a podcast with my law partner, Ron Sixtus, just a few years ago. That podcast can be accessed through our website. The podcast is named Next Lawyer Up, and Max appeared on episode, I believe it was episode 17, Max, yep, on our screen now, way back in July of 2017. Time flies.
Yeah, Ron came up to Shelby, and we did that in my office.
It probably wouldn't have had these technical problems if I'd done that, Max, but
I enjoyed doing that with him. In fact, my grandfather was lieutenant governor from 1916 to 1920 also. And when he ran for governor in 1920, he lost because he had supported the 19th Amendment and had supported the rights of African Americans at that time, something I'm very proud of that he did, but he lost the governor's race in 1920 because he supported women and African Americans at that time. He won in 1928 and served to 32, which I've tried to figure out some way to talk to him, if possible, Brad, because I think we're going into another Great Depression, and that's when he served.
Wow. I've read a lot about him and his career in Washington also, of course, and heard you speak of him. And I'm sure he's as proud of you, Max, as you're proud of him and his accomplishments. Max, we because of technical difficulties, had a little interruption, and I know that you have obligations later this afternoon. So we do have some questions that have come in that I want to get to you. So first question is, if I have had a mortgage mod done that I didn't request, what steps should I take at this point?
Well, I would suggest that anybody that is in that situation that contact me, because we'd want to know about it. Max Gardner at maxgardner.com is my email address, and that's the easiest way to get in touch with me. Anybody can remember that, Max Gardner at maxgardner.com. And
we have it across the screen also, Max, that and your phone number so that people can track you down. And as an attorney here in Alabama, I would also, this is technical litigation, I would encourage you to get in touch with Max Gardner, and the website again is on our screen, and he can help you with these type issues. So
I would just say, Brad, that you're offering free consultation. We're offering free consultation to any consumers, whether you're thinking about bankruptcy or not. If you're thinking about a forbearance, I would strongly urge anyone to contact a lawyer. I think many lawyers will help you out for a free consultation to tell you about forbearance and the CARES Act and how it works, and make sure you know what you're getting into before you jump into this. I know forbearance is something that can help people, but there's, when you pass a massive bill like Congress did back in March, and it affects so many areas, there are going to be a lot of unintended consequences that you never think of, and this one is full of them.
That's excellent advice, Max. And certainly anyone that wants to contact our offices, we also can offer assistance. But if you fall into that special class where you've been granted a modification that you didn't request, I would encourage you to reach out to Max Gardner. Max, if a consumer has been offered a modification, is there a certain period of time they have to decide whether or not they want to take it? For instance, perhaps they were working back at the beginning of COVID and didn't need it, but now are without income.
Well, it's in effect for a year, so it sunsets in a year, and it's totally up to the consumer. I think you just want to know what the implications of a forbearance are. If you're in a forbearance, you certainly have the right to make partial payments, like half the payment, and that would decrease the amount that would be owed at the end of the forbearance period, or you could make a full payment. You could get in a forbearance plan and make a full payment each month, and if you didn't need it, then you didn't need it. The thing you just need to keep in mind is the impact that's going to have on your credit. A forbearance is going to be reported as such on your credit, and just that report may be something that is going to limit your ability to immediately get new financing or refinancing. I would just be aware of that. If you want a 6-month forbearance, and the CARES Act makes it clear, if you're talking about a federally guaranteed loan, you have the absolute control over it. If you ask for a 6-month, 180-day forbearance and get it, and you decide after 2 months that you don't need it anymore, you have the absolute right to cancel it. The control is totally with the consumer borrower, and it does apply to bankruptcy. It does not make any difference if you're current or behind. If you're behind on your payments right now, say 3 months behind, you can still contact your servicer, and if it's a federally guaranteed loan, you can ask for a forbearance, and you have the right to get it. So it may be a way to deal with a situation and avoid a foreclosure. And I'd say don't forget, under Regulation X of the Real Estate Settlement Procedure Act, you can go through the loss mitigation procedures there and delay a foreclosure if you start soon enough for another period of 120 days. So there's a lot of remedies available to homeowners who are impacted financially by COVID-19. And I just think you need to get with a lawyer. I think anybody will give you free advice about, here are the options. If you want to pursue those, then we can get in here and do it the right way. I'm not saying everybody should file bankruptcy. Yeah. I'm saying there are a lot of non-bankruptcy options. I have advised people to, I really think, Brad, that we're headed for a very serious recession, great recession. I think it's going to be much worse than people think. And conserving cash and figuring ways you're going to deal with what I see coming as something very bad, consulting with a lawyer now and understanding your rights and remedies and what you can exempt from claims of your creditors in the worst case scenario and what you cannot, exemption planning. These are things you should be doing, because there is a train coming down the track, folks, and it's not going to stop. And we're on the railroad tracks, and that light is getting closer every month and every day, every week. Absolutely,
Max. We've been encouraging folks, just because you call a bankruptcy attorney or an attorney that does bankruptcies doesn't mean that you need to file bankruptcy, but you need to know your rights. you need to reach out to an experienced attorney and learn what your rights are with respect to exemptions. Because if Max and a lot of people are right about what's coming down the line, you need to do all you can to protect your assets, to protect your family. So reach out for that initial free consultation at this point. You can call the number on our screen to schedule an appointment with our firm, or go to our website and gather more information before doing so. But we'll be glad to help you, and I know Max will also.
Yeah, I mean, there's a lot of mistakes you can make. I mean, I had somebody that contacted me a week or so ago about one of these problems, and what they had done is paid off all their credit card debt. And I think that's probably the worst thing you could do if you think you're going to have serious financial problems and maybe end up in bankruptcy. So I'm telling people to conserve cash, get with a lawyer, get proper advice, and understand what your legal rights are. I'm not saying you need to file bankruptcy now by any means, not trying to drive people to bankruptcy, but know what your options are and know how to conserve your money and wisely spend your money and what debts to pay and not to pay at this point. I think that's the major thing. I predicted a recession. But I do predictions every January 1. I predicted Tiger Woods would win the Masters last year in the Washington Nationals World Series. So I had a good year. I hope I had a bad year, but a great recession in the fourth quarter was what I predicted January 1. And I did not even have a clue about COVID-19. You put that on top of the financials I was looking at January 1, and I hope to God I'm wrong, but I think we're in for a very difficult time. And I see a long haul for this economy to recover. I'm talking about 10 to 15 years.
Max, you mentioned the individual that had paid off all their credit cards. Another thing we hate to hear when people tell us they've taken money out of their 401k to address their financial concerns. Could be the worst thing you do.
That's exactly what they had done. There's a provision in the CARES Act. You can take money out of your 401k without the normal penalties. And that's exactly what they had done, Brad. And it's exactly what they should not have done.
Right. And the reason why, of course, is although there aren't any tax penalties, that money, while it's in your 401k, is completely protected from your creditor. So if you do need to seek bankruptcy protection in the future, and we hope you don't, but if you do, that money's protected. So leave it there and talk to an attorney and get good, sound advice before you take an action like that. Max, you mentioned earlier, and I'm worried that we may have missed it when we had technical difficulties, but many of the protections of the CARES Act only apply to these federally guaranteed mortgages. How does an individual determine whether or not their mortgage is federally guaranteed?
Well, Fannie and Freddie are pretty easy. They have lookup sites. You can Google Fannie lookup or Freddie lookup. You go to the site, you put in your name, address, and the last 4 digits of your social, and Fannie will tell you in response to that inquiry whether or not Fannie owns your loan or Freddie owns your loan. If you've got a Fannie or Freddie owned loan, that's a federally guaranteed loan. The others are through another federal agency, Ginnie Mae, and those are FHA, VA, rural housing, USDA loans. They also have a website you can go to. It's not as clear as or transparent as Fannie or Freddie, but most people know if they have a VA loan. Most people know if they've got an FHA loan or a rural housing loan. If you don't know, you can go to their site and get information to determine that. But that's really where the legislation comes into play and where your maximum rights are on a forbearance. Every servicer, though, for even a non-federally guaranteed loan is offering a forbearance. Motor vehicle creditors, Toyota Finance, Ford Finance, they're all offering forbearances, and those are not covered by the CARES Act. They're just doing that.
Right.
So you need to know who owns your note, number one, on a mortgage, to make sure you've got the maximum rights. And I just think that the forbearances I have done for clients, I have worked out how we're going to resolve the payments that were forborne at the end of the period on the front end. I want to do it on the front end. I want to know if we do a 6-month forbearance of a federal guaranteed loan, how are we going to resolve those 6 payments at the end of the 6 months? I want to know that on the front end and not the back end.
Max, I wonder if you could, for our viewers that may not understand when you refer to who owns the loan and who services the loan, if you could just give a brief explanation. Just because I owe or make my payments to ABC Bank, that doesn't mean that bank owns my loan. Is that correct?
That's right. A mortgage servicer is the person, the entity that sends you the monthly billing statement. That's the entity you make the monthly payments to. That's who you're interacting with if you've got issues or questions about your mortgage. That is the mortgage servicer. That is not the entity in 99% of the cases that owns your note, the promise to pay you signed when you took out the mortgage. That is going to be owned by either securitized trust that's through one of the federal agencies, Fannie, Freddie, or Ginnie. And I'm saying Fannie and Freddie are federal agencies because they're under a federal conservatorship and have been for 10 years. Or it's owned by a private label trust that owns your note. And it's very important to understand the difference. I think most consumers that come in to see me, they've got a statement from, and I'm not going to mention any names for obvious reasons, but we all know who the servicers are. They think that's who they owe the money to. They think that's who owns their note. And there's a major difference between the two.
Right. So many folks will come in and they'll say, well, my mortgage was sold from one entity to another. And usually that's not what happened. It's just the servicing of the mortgage has changed.
What we have seen in the last 2 years, Brad, more than ever, especially in the last year, our mortgage servicing rights have value, and mortgage servicing rights are sold and transferred all the time. So somebody will come in to see me and say, Max, my mortgage has been sold from A to B because I'm getting my statements now from B.
Right.
All that's happened is the right to service your loan, to collect the payments, send you the billing statements, and decide about whether to foreclose, look at loss mitigation options, modifications, forbearances. That's the servicer. That is not the party that actually owns your note.
Max, a very important question just came in. So you mentioned earlier to be cautious about going to the mortgage servicer's website and clicking around on the website. I know that also people have problems calling customer service lines. What is the best way to communicate with your mortgage servicer and to verify anything they've told you?
Well, it's very hard to contact them by phone. They're very busy. You may be talking to somebody in India or the Philippines or Central America. They've outsourced the servicing rights to save money overseas. I think the best way is to send them a written request for information. And you have the right to do that. There's an address on your monthly billing statement that says if you have any disputes or need information about your loan, send it to this address. And that's the address you have to use. Is you can go to the website and look for notices of error or requests for information. It's the same address. And I think a written letter to that address, and I advise people to send it certified mail return receipt so you can prove that you actually sent it and they got it, and keep a copy of what you sent them. Don't just mail it to them and don't retain a copy. And they have a certain time period to respond to that. It's 30 business days to give you information about your loan, and you're going to get something back in writing. And I really think that's the best way to communicate with them. Even if you think something is wrong about your mortgage, if you're in a forbearance and you don't think you should be in one, send them a notice of error, just a letter to that same address saying, I never asked for a forbearance. I didn't want a forbearance. How did I get it? Why did I get it? I want out of it. I want it off my credit. And under the CARES Act, you get a free credit report now once a week. You have the right to get a free credit report from Equifax, Experian, or TransUnion. If you've got any doubts about whether you've been put in a forbearance without your knowledge, get your free credit report and check it out, and you can see if a forbearance code is on there for your servicer. The servicer reports to your credit, not the owner of your note. So if Fannie owns your note, Fannie does not report to the Equifax or Experian or TransUnion. Your mortgage servicer does that. You can see if they're showing payments that were actually received, in July or June, and you can see that forbearance code, and you would know right then. They have put me in one because I went on their website and clicked on the button, information about forbearance or CARES Act.
I want to underscore something Max just said because it's so important. Folks, if you need to write to the mortgage servicer, don't use the address you use for making payments. That letter is going to end up in some lockbox somewhere and it may never be seen. You've got to send it to the address designated for communications of this sort. And this is not only with mortgage servicers. If you're dealing with a credit card company or a car lender, whoever it is, don't just send your communications, your important communications to the payment address. Use the address they designate for correspondence of this nature. And you'll find it on your statement somewhere, or if not on the statement, it'll be on their website. That's very important to know.
A qualified written request address, a request for information, a notice of error, any disputes about your loan, and it'll have a specific address. And you really have to send it to that address. There are legal reasons you would do that, and practical reasons too you would do that. But if I'm corresponding with any creditor, I want it in writing so I can prove what I asked them and then what they told me back in writing. And there's really no magic words. You can just write out the questions you have. There's no legal words or magic words or anything like that you have to use. Just simple, plain English. Here's my problem. Here's my question. Here's my dispute. Keep a copy of it, send it certified mail return receipt, and
keep the green cards.
You can also write your servicer a request for information and ask them to tell you who owns your note, and they have to give you that information back in 10 business days. You can ask them for a payoff on your loan by sending that request for information to that same address, and they have to send that back in 7 business days. So that's another way you can find out who owns your note, and they have to give you that information in 10 business days from the date they get your request for that information.
Max, we have some questions, the answers to which are going to be somewhat state specific. Questions like, how long will I be able to stay in my home following a foreclosure? How long a foreclosure will take? The time that the foreclosure takes is going to vary a great deal based upon the state you live in. There are states that have judicial foreclosures that take many, many months, sometimes years. Others that just have notice foreclosure, and it can be very quick. The states I practice in, Alabama, Mississippi, and Tennessee, the foreclosure can take place very quickly because we don't have judicial foreclosure, which means there's no court proceeding. There's just a publication in a newspaper and then a sale. So act quickly. Before we end, Max,
be sure and open every letter you get from your mortgage servicer and read it. Don't just put them in a pile and say, oh my God, this is bad news. I'll look at it next week. Open it up, look at it, see what it is. It may be a notice of acceleration or a notice of intent to foreclose. And you want to get to an attorney as soon as possible, because you have rights under Reg X of RESPA to ask for loss mitigation options, and that's going to delay depending on timing, when they can proceed forward with that foreclosure. So I'm not trying to drum up a legal business, but I want folks to understand their rights. And this is a time, we're entering a time period where you really need to understand your rights. And attorneys will tell you what your rights are. I'm not going to charge somebody to tell them, here are your options. Here's what you can do. And if you want us to help you, here's what we can do, and this is what our fee would be. But I'm not going to charge anybody a fee to tell them what their legal options or rights may be. And I think most attorneys that are like Brad and myself, that the attorneys who've been to my boot camp, we've had 2,500 over 15 years who have attended. They want to help you. They're here to help you, and we're the first line of defense. I'm telling you. And there's a lot of areas, rural areas, that don't have attorneys anymore. That's another problem, Brad. So, Brad's in 3 states, and our job really, as I see it, and I think most attorneys that are on doing consumer work like we are, we want to make sure you do the right thing and you know what the right thing is to do.
Absolutely. Max, before we finish, I want to give you a chance to talk about a topic. Max Gardner, folks, knows more about Chapter 13 bankruptcy than I think any attorney in the country. Chapter 13 is not a liquidation bankruptcy. It's a bankruptcy. It's a type of legal proceeding that allows you to restructure your debt, hopefully keep your home. Max, viewers have heard me tout Chapter 13 and the benefits of Chapter 13, but if somebody calls you and is facing a foreclosure, there's a sale scheduled, they're beyond time to do one of these mod programs, or the mod hasn't worked, tell me about the attributes of Chapter 13 bankruptcy.
Well, the key thing about Chapter 13, Brad, is that once you file a Chapter 13 bankruptcy case, and what's called an automatic stay or automatic injunction goes into effect. And that's like a freeze gun. It stops everything cold, and it stops the foreclosure. And if you're 9 months behind, you can propose a Chapter 13 plan to cure those arrears over a period of 36 to 60 months and resume your regular payments. We also have a loan modification or mitigation program in Chapter 13 in North Carolina, where if you file Chapter 13, you can go into the loss mitigation program and have a good chance of modifying your loan by reducing the monthly payments, maybe eliminating and forgiving a substantial part of the principal, restructuring your loan, extending the term, reducing the monthly payments. So there's a lot of benefits to Chapter 13. My classic thing is the consumer comes in, maybe he doesn't have a home, but he's got 2 vehicles and he wants to keep those, and he wants to do a Chapter 7. Now, to keep those vehicles in a Chapter 7, you're going to have to do a reaffirmation agreement, which means notwithstanding the Chapter 7, I'm still going to owe that debt. I tell that person, let's get into Chapter 13 and see if you can make the payments on that debt. And if you can't, then we can convert the Chapter 13 to a 7 and let the cars go and cancel the debt. Or we can just dismiss the 13. You have an automatic right to dismiss a Chapter 13. In almost every jurisdiction, that's still the rule. And I think it should be the rule everywhere. So I look at it as kind of in golf, they have the mulligan rule on the first tee. You get that first free shot that goes way out of bounds, you get a second chance. And I look at Chapter 13 that way. And I'm a firm believer in trying to do a 13. If it doesn't work, you have the absolute right to convert it to a Chapter 7. So if we want to try and make it work and see if you can do it, and we may be able to reduce the monthly payments on your motor vehicle in Chapter 13, depending on how long it's been since you purchased that vehicle and got the credit on it. So Chapter 13 is my most favored nation bankruptcy, Brad.
Now, Max, and the important thing for people to know, in my 30-something years of practice and your 40-something years of practice, we've represented thousands and thousands of individuals that have gone through Chapter 13 and are doing just great after their discharge. They've been able to put their life back in order. They've been able to protect their home or cars and their family and get on to brighter horizons, Max.
Right. I mean, it's bankruptcy is not the end of the world. The president has been involved in 5 bankruptcies, so I think that and he's president, so apparently it doesn't disqualify you from the highest office in the land. And I've got my book they went broke. But Brad, I think you've seen it many times.
I have.
At boot camp, and I give it to everybody that comes into the office, and it's famous people who have filed bankruptcy over the years, and I think people are shocked when they look at that book. I don't think it's a badge of dishonor. I always go back and quote Deuteronomy in the Old Testament that the law in the Old Testament back in olden times was at the end of every 7 years, all debts were canceled automatically as a matter of law. And I tell people, where do you think Congress got Chapter 7 from? They didn't make up a number. They looked at the Bible and looked at the 7-year Jubilee and that's where they came up with Chapter 7. So I have people that have religious issues about bankruptcy, and I like to open the good book and go right to Deuteronomy and say, look at it right here. It's the 7-year Jubilee. Back then it was automatic. Now we've got to do it to make it happen. But
Max, our firm on our website that's been on the screen a couple of times while we've talked, right on the homepage, links to an article by Max Gardner about bankruptcy in the Bible that you wrote some time back. That's just a tremendous insight and really gives comfort to a lot of people that visit our website. My friend, I promised you that I would finish this so that you could get to a hearing that you have at the top of the hour. I want to thank you, Max Gardner, for not just for appearing today, but for the many attorneys you've taught important lessons to throughout the years, for the many people you've helped. I want to let viewers know that options do exist. You need to be proactive. You need to reach out for help. If you know somebody that you think might benefit from what you've heard today, this broadcast will be available on our firm's Facebook page and our website. Please refer them back to it. And if you're an attorney and you want to be taught by one of the best, I strongly encourage you to follow the link that's been on our screen and the phone number to Max Gardner's Consumer Academy. Go to one of his boot camps. You just won't learn anything better anywhere.
Brad, I would just say for all the consumers out there that may be watching this is don't get into a state of denial.
Right.
Be proactive. Take the bull by the horns, find out what you can do, what your options are, how you should spend your money or not spend your money, what sources you should tap or not tap for cash if you need it, what would be exempt from your creditors no matter what happened to you. Be proactive and learn your rights in advance. Don't deny it, don't avoid it, don't put it off, don't hope things are going to get better. Don't think your boat's going to come in or you're going to win the lottery or the scratch-off card or the public clearinghouse check is going to come in. Assume the worst and do the best. And the best is to find out what your rights are and what you should be doing right now. And I think we should all be planning for the very worst. I hate to say it, but I think that's what's going to happen. And I hope I'm wrong.
Well, Max, I hope you're wrong too, but I've known you long enough to know that you're probably right. I echo Max's sentiment. Be proactive, folks. Reach out now and find what your options are. Get good advice from a qualified attorney. But on behalf of my friend Max Gardner and all of us here at the Bond & Bodas Law Offices, we thank you for visiting today and encourage you to tune in every Wednesday at 1 o'clock Central Standard Time here on Facebook Live. God bless all of you and good luck. Thank you, Max Gardner.
Thank you very much, Brad. I enjoyed it. And be safe. Everybody be safe and wear your mask, please.
Amen.
It's not a political issue. This is a health issue. And do the right thing. Wash your hands, do everything they say to do. I don't care what people are saying. Follow those rules and be careful, be safe, take care of yourself and your family.
Amen. Thank you, folks. Thank you, Max.